Just like to welcome everybody here on the Standing Committee on Access to Information, Privacy and Ethics, meeting 160. We're dealing with committee business and dealing with two motions. First of all, from Mr. Kent and then Mr. Angus. But I would like to, first of all, welcome some members that are with us today that aren't usual members of the Ethics Committee. And I believe Ms. May was supposed to be here. I don't see her, though. We're going to welcome her today, Ms. Raitt, Mr. Polyev, Ms. Ramsey, and Mr. Weir. I think that's everybody. And while the extra members are not members of this committee, as a courtesy, we typically give guests the right to speak. Having said that, I'll turn the floor to Mr. Kent.
Thank you, Chair. And good afternoon, colleagues. Colleagues, you'll recall that on January 10th, 2018, this committee met in special session with the former Ethics Commissioner, Mary Dawson, enabling her to brief us on the Trudeau Report, what turned out to be the Trudeau Report number 1, the results of her investigation into the Prime Minister's illegal vacation. Ms. Dawson spent 2 hours with us, providing important, relevant details on how she came to find the Prime Minister guilty of 4 violations of the Conflict of Interest Act. The findings of the Trudeau Report number 1 detailed unacceptable ethical lapses by the Prime Minister. But the Trudeau Report number 2, the scathing report released just last week by the current Ethics Commissioner, Mario Dion, details many more serious violations of the Conflict of Interest Act, up to and including, by any reasonable measure, attempted obstruction of justice. Or, as Commissioner Dion concludes, actions, quote, contrary to the constitutional principles of prosecutorial independence and the rule of law, close quote. Which is why, colleagues, my colleague, Mr. Gourd, and I wrote the following letter to the chair of our committee, Mr. Zimmer. And that letter said, and I'll read it into the record, yesterday, the Conflict of Interest and Ethics Commissioner released the Trudeau II report. The report found the Prime Minister directly and through his senior officials used various means to exert influence over Ms. Wilson-Raybould. The authority of the Prime Minister and his office was used to circumvent, undermine, and ultimately attempt to discredit the decision of the Director of Public Prosecutions, as well as the authority of Ms. Wilson-Raybould as the Crown's Chief Law Officer. This is incredibly concerning. These findings show that Justin Trudeau used the power of his office to reward his friends and to punish his critics. This is a grave situation. Not only is Mr. Trudeau the first Prime Minister to have been found guilty of breaking the law, he is a repeat offender. Canadians deserve fulsome answers to the many remaining questions. We ask, again, my letter continued, that you urgently convene a meeting of the Standing Committee on Access to Information, Privacy and Ethics for the purpose of receiving a briefing from the Conflict of Interest and Ethics Commissioner. And we would be prepared to move the following motion, the motion, colleagues, which is before us today, that given the unprecedented nature of the Trudeau II report, the committee invite the Conflict of Interest and Ethics Commissioner to brief the committee on his report, and that the committee invite further witnesses as required based on the testimony of the Commissioner. Now, colleague, in this committee's previous meeting, previous consideration of opposition motions regarding the SNC-Lavalin scandal, Mr. Erskine Smith, speaking for all Liberal members of this committee, characterized those motions as premature until the Justice Committee completed its study and the Ethics Commissioner completed his investigation. The Liberal majority voted against all opposition motions. But now we know the chair and Liberal members of the Justice Committee shut down their study prematurely, and a week ago the Ethics Commissioner published Trudeau II report, a report reporting to parliamentarians and to all Canadians that their Prime Minister broke the law in improperly attempting to influence the Attorney General, quote, in many ways. It confirmed Canadians' decisions and suspicions and much more. It is a weighty report, even though the Commissioner states that his investigation is incomplete, even though he reports he was prevented by the clerk of the Privy Council from access to relevant witness testimony under a blanket confidentiality shield, thus blocked from looking at the entire body of evidence. Despite all of those challenges, the Ethics Commissioner declares he gathered sufficient factual information to properly determine the matter on its merits, and he has itemized those facts in great detail. Again, as the Commissioner writes in his conclusion, the Prime Minister's actions were improper and contrary to the constitutional principles of prosecutorial independence and the rule of law. Colleagues, these detailed findings of fact of a Prime Minister's actions are unprecedented in Canadian history. And I hope that you'll agree that a debriefing session with the Ethics Commissioner as soon as possible is as appropriate now as was the debriefing session of Trudeau Report 1 with the previous Commissioner last year. Thank you, Chair.
Thank you, Mr. Kent. We have an order. I have Lisa, Charlie, Pierre. So, Lisa.
Thank you very much, Mr. Chair. I echo the comments made by Mr. Kent with respect to the desire for this committee to move forward with hearing from the Ethics Commissioner. Why I'm here today, Mr. Chair, is because I was a member of the Justice Committee that was shut down in March of this year in favor of the Ethics Commissioner conducting his study. A letter was sent by the members, the Liberal members of the committee on March 18 to the chair of the Justice Committee, and those members were Randy Boissonneau, Ikra Khalid, Ali Assasi, Ron McKinnon, and Colin Fraser. And they said their conclusion after the testimony heard at the Justice Committee that all the rules and laws were followed. They also said that they believed that the ongoing study of the Ethics Commissioner was the appropriate way forward, and that they had faith in the Ethics Commissioner. And they also noted that the opposition parties rushed to judgment before hearing all the relevant information. Following the shutting down of the Justice Committee, Mr. Chair, the Ethics Committee then tried to bring the issue to this area for discussion. And on March 28, again, the matter was blocked. And as a result, we were left with the Ethics Commissioner as being the only venue where an investigation was taking place. And indeed, if you take a look at Hansard for the period of time in April and in May of 2019, when asked questions by members of the opposition, the Prime Minister said continuously and reiterated continuously that he had faith in the Ethics Commissioner in conducting his study. However, most recently, the Prime Minister, in commenting on the Trudeau 2 report, which was issued last week, said two things that caught my attention. The first thing he said was that we fully cooperated with the Commissioner. And the second thing he said was that I disagree with the conclusion. These two statements carry great weight. They're from the Prime Minister of Canada, and they're the only statements regarding the Ethics Commissioner's report on record from the Prime Minister in this matter. And it is unfair that the Ethics Commissioner has no voice and no venue to be able to respond to these two assertions the Prime Minister made. Now, there is provision in the Conflict of Interest Act to allow for somebody who's being investigated to be able to appeal the ruling of the Ethics Commissioner. And we find ourselves in some uncharted territory because what the Prime Minister seems to seek to do is to change the report of the Ethics Commissioner by saying that he doesn't agree with it and saying that he fully cooperated. Now, the evidence of the Ethics Commissioner in his report is that, to the contrary of the Prime Minister's statement, they did not fully cooperate with the Commissioner at all. And indeed, the Commissioner took great lengths of noting the concerns that he had with respect to whether or not it was appropriate, the way in which the Prime Minister sought to produce documents, be interviewed, and at the end of the day, determine whether or not a waiver was extended to allow the Ethics Commissioner to have access to all the information that he deemed appropriate for the study. Where we find ourselves in uncharted territory is this. The Conflict of Interest Act does not allow for the Ethics Commissioner's report to be changed. No committee of Parliament, no vote in the House of Commons can change the contents or the decision of the Ethics Commissioner. The report is what it is and stands as it is. Yet the Prime Minister is now trying to say that the report is wrong. But good news for him is if he chooses to, in fact, go ahead and appeal the ruling of the Ethics Commissioner, he has the ability to do so. And he can do that by launching a judicial review at the Federal Court of Appeal. That is the appropriate venue for the Prime Minister to challenge the Ethics Commissioner, not in the court of public opinion, which is he's seeking to do right now. Now, why does this all pertain to the visit of the Ethics Commissioner? Well, I do believe, as a lawyer, that there are rules regarding procedural fairness. And clearly, the Prime Minister is not going to be seeking judicial review of this ruling. He hasn't said he was going to, and in fact, it doesn't seem as if he has any plans to even address that question. But that being said, it still is fair for the Ethics Commissioner to be able to respond in some way, shape, or form to questions from the committee, from members of Parliament who seek to understand the discrepancy between what the Ethics Commissioner found and what the Prime Minister is attempting to assert to the Canadian public. That is the issue of public interest. That is so important in having the Ethics Commissioner come and testify. It is the foundation of our rule of law that accusations are allowed to be responded to and rebutted. That, I believe, is something that as parliamentarians we owe to the Ethics Commissioner, who does his work at the request of all parliamentarians and indeed is voted on by all parliamentarians to sit in his job as the Officer of Parliament. In summation, Mr. Chair, I would say this, that after months and months and months and months of the Liberal members of Parliament on the Justice Committee, on the Ethics Committee, the Prime Minister himself, and every minister who answered a question in the House of Commons with the refrain that we trust and believe in the independence of the parliamentary officers and we will listen to them and we will cooperate fully. It is owed to all of these comments that the Ethics Commissioner does have the ability to come in and be able to respond to the two things that the Prime Minister has said on this report, which is one, that he fully cooperated with the Commissioner, which the Commissioner says is not the case, and number two, that he disagrees with the conclusion without telling us which conclusions he disagrees with. So with that, Mr. Chair, I pass the floor on to the next individual, and I hope that my colleagues on the other side will, in fact, allow for the Ethics Commissioner to be able to appear today in fairness, in justice, and to uphold the administration of our procedure.
Sure. Speaking order is Mr. Angus, Mr. Polyev, Ms. May, Mr. Weir, and Ms. Ramsey. So go ahead, Mr. Angus.
Thank you. Merci, Monsieur le Président. C'est simple. La loi
Thank you, Mr. Chair. It's simple. The law applies to everyone. It's a fundamental principle for Canada. It is the role of this committee to guarantee the obligations to ensure an ethical standard for all parliamentarians. Mr. Dion's report is clear. Mr. Trudeau broke the law of Canada. He had a plan to undermine the role of Canada's Attorney General to help his buddies at SNC-Lavalin. That is unacceptable in Canada for the Prime Minister's office to be an open bar for lobbyists. We have an obligation to respect the ethical code of Parliament and Canada.
understanding that Mr. Dion is ready to speak. Is that correct?
That is, just to be clear, he said he'd make himself available on short notice. Based on some questions from all parties here, he's made himself available today via video conference. So he's standing by if the motions are to pass. Yes.
Because he reports to our committee. He's an officer of Parliament. And as an officer of Parliament, his job is to ensure that every parliamentarian meets the highest ethical code. And when you're the Prime Minister of this country, you're expected to meet the highest ethical code. So we have the Commissioner ready to speak, to respond to the report, as his normal function is to come to our committee and present that report. We need to hear from Mr. Dion, because to have the Prime Minister of the country to be found guilty of breaking the law, to aid very, very powerful people in writing a piece of legislation that existed only for that company. It was written for one purpose, to get them a get out of jail card. And then to have a campaign involving so many key people in the Liberal government to put pressure on the Attorney General and the independent prosecutor is not acceptable. Either we have the rule of law in this country or we don't. And that's what the fundamental question is. So for the Prime Minister to invoke the Mark Zuckerberg defense, which is, hey, thanks a lot for finding me guilty, I'm just going to blow you off. Mark Zuckerberg may get away with that because he lives in another jurisdiction and he's a gazillionaire. But Justin Trudeau cannot blow off the Ethics Commissioner of Canada. If he wants to do that, then he needs to come back and bring a law in that says he's no longer bound by any laws. But right now he's bound by the Conflict of Interest Act and he's been found guilty. We see that there's a pattern of interference by his office and the Privy Council that interrupted 9 potential witnesses to give testimony. We need to know who those 9 witnesses were. We need to know how extent was the interference and the obstruction in the work of the Ethics Commissioner, because the Ethics Commissioner reports to us. It is our job to go back to Parliament whenever there's a problem with lobbying, the work of the Privacy Commissioner, the work of the Information Commissioner, the work of the Ethics Commissioner. When their work is being interfered with for political purposes, it is our job to put our partisanship aside and say we have to have a standard that all parliamentarians should meet, and the Prime Minister has failed to meet this. So I'm asking, Mr. Chair, that you have the power to ask the Commissioner to report to us. I would like you to see you exercise that. He has to report to us. This is his job. Any attempt by the Liberals to stop that will be a pattern of continuing the interference and the obstruction in the fundamental principles of the parliamentary system.
Thank you, Mr. Angus. Next up, Mr. Polyev.
Mr. Chairman, you've told us that the Ethics Commissioner is standing by, ready to testify about his guilty verdict that he rendered against the Prime Minister last week. Now, the Prime Minister's MPs across the way will decide whether, after silencing Jody Wilson-Raybould, they will silence the Ethics Commissioner as well. Whether they will vote to ban the Ethics Commissioner from appearing at the Ethics Committee. And if so, what that says about the ethics of this government. It's important to recap why we're here. SNC-Lavalin is accused of over $100 million of fraud and bribery, accused of stealing over $100 million from among the poorest people in the world. Instead of going to trial, the company convinced the Prime Minister to change the criminal code, allowing alleged corporate criminals to get off of a trial by signing a deal to apologize and promise never to do it again. The Prime Minister passed that in an omnibus bill and then demanded his Attorney General extend such a deal against the earlier decision of the top prosecutor. She refused, so he fired her. She spoke out, so he kicked her out and shut down the numerous parliamentary inquiries into the matter. Since then, he has told us, wait for the Ethics Commissioner to issue his verdict. And so we all waited, assuming that when that verdict came, we'd all be able to hear about it right here in the Ethics Committee. Here today, we will decide if, in fact, that will happen. We know that there's a lot more to this story the Ethics Commissioner has not been able to tell. At least 9 witnesses were prevented by the Trudeau government from telling their full story because of a government-imposed gag order under the guise of cabinet confidentiality. There are many mysteries that we need to unravel in this matter, and only by hearing witnesses can we do so. One of them is this famous 9,000 jobs claim. You know, most of SNC-Lavalin's jobs in this country are for construction work done in this country. They're going to be building a north-south transit project here in Ottawa. Well, they can't build that in Hong Kong or in Munich and then drop it out of a helicopter on the nation's capital. That work will have to be done here. The headquarters must stay in Montreal until the year 2024, according to a loan agreement with the Quebec pension plan. The CEO of the company said that the company is not moving anywhere, and we know that leaving Canada would not exempt the company from prosecution or conviction. So we've tried to ask the government where this claim about jobs has come from. In fact, Ms. May asked some of the best questions on this matter. She asked Mr. Wernick, in the public interest then, Mr. Wernick, in preparing advice to Cabinet, what work did you do to assess the threat of jobs? Did you look at the commitments made to the government of Quebec not to move the headquarters as mentioned? Did you look at the current financial status of SNC-Lavalin? Did you, in fact, have an independent assessment of whether there would be any impact on jobs from a decision to proceed to the Director of Public Prosecutions had decided to proceed? Response, no, because the file was entirely in the carriage of the then Minister of Justice. Apparently, the Justice Department now does jobs assessments. Gerald Butts had a different story when Ms. May asked the same question. She asked, is there any evidence that jobs were actually going to be at stake by letting this go through the courts and letting the independent Director of Public Prosecutions and the Attorney General do their jobs? Gerald Butts, I can't recall anything specific. He also said, my understanding from the department, that the jobs claim was his understanding from the Department of Finance briefings. But I have to say it's been a long time. So now we're claiming that the Department of Finance has proof of this 9,000 jobs claim. So let's turn over to the Finance Minister. Well, in the Ethics Commissioner's report, I quote, when asked if he, Morneau, or his office had undertaken a study or analysis of the economic impacts of the Director of Public Prosecution's decision, Morneau testified that none had been conducted. And then a reporter on March 7th asked the Prime Minister the following question. Both Mr. Wernick and Mr. Butts testified they had no direct evidence that 9,000 potential job loss. Did you have any evidence of 9,000 jobs being lost? Response, we had heard representations from various sources, including the company itself, that this was an issue of deep concern to them and that it could potentially have consequences as dire as the company having to leave Canada altogether. Now, you notice he didn't provide any evidence, but he did claim that the company might leave the country altogether. Well, let's turn to the Ethics Commissioner's report on that. Top Trudeau advisor, Mr. Bouchard, notes from the same October 23rd, 2018 meeting with senior officials of the Privy Council office show that they also discussed SNC's Board of Directors' potential plan to move the corporate headquarters, but the Caisse de dépôt et placement du Québec would not let that happen. In other words, Mr. Trudeau's office knew in October, months before he made the claim that the headquarters would leave, that eventuality was impossible. So given that this was not about jobs, the most important question I want to ask is what motivated this? What on God's green earth would compel a prime minister to pass a law at the request of one company, exempting corporate criminals from prosecution, put pressure on his attorney general to overturn his top prosecutor, and then fire her when she refused to do so, given that it was not about jobs? We know the SNC-Lavalin gave $100,000 of illegal donations to the Liberal Party. We know they swarmed Parliament Hill and the PMO with lobbyists. There was a revolving door between this government and SNC-Lavalin. We need to know the real motive for helping protect this company. Donc, nous sommes ici au Comité de l'éthique.
So we are here at the Ethics Committee to hear from the Ethics Commissioner. This government has tried to gag the former Attorney General. Will Justin Trudeau's Liberals use their majority to do the same thing? Will they prevent the Ethics Commissioner from appearing before the Ethics Commission, the Ethics Committee? Will they try once again to camouflage things so that Canadians don't have the truth before the election. That is the decision before us. Thank you very much.
Thank you, Mr. Polyev. Next up, we have Ms. May.
Thank you, Mr. Chair, and thanks to the committee for the opportunity to speak. And thanks to Mr. Poilievre's intervention, I don't have to go through a recitation around the jobs questions that I asked in the Justice Committee. I'm deeply troubled by what faces us, and those of all of you around the table I regard as friends. I try to approach things in a very nonpartisan way, and that's very hard on the eve of an election. Everybody goes into hyper-partisan mode, and this is, in a lot of ways, red meat right before an election, and I know that. But something was really wrong here. Something's deeply wrong here, and I beg my friends around the table to allow Monsieur Dion to speak to us. I thought I knew what had transpired on the SNC-Lavalin mess based on the testimony of our former Justice Minister and former Attorney General. Her chronology, her notes, I thought covered everything that had occurred, and I believed her in every syllable. But Mr. Dion's report has shaken me far more than our former Attorney General's testimony, and I'll tell you why. We now know that there were meetings that took place on the edge of other international gatherings, like in Davos, that the Minister of Finance, Bill Morneau, took a meeting with the CEO of SNC-Lavalin, that the idea of changing our law to insert a deferred prosecution agreement into the criminal code came from SNC-Lavalin for their use specifically. No wonder the machinery of government began to panic when the plan wasn't working out because they had a hiccup because the Minister of Justice and our Attorney General at the time respected the principle of prosecutorial independence and wouldn't intervene against the Section 13 report of the Director of Public Prosecutions. This is a critical point. There were other ministers involved. I thought, and I will admit that I thought this because I bend over backwards to be fair to everyone concerned. I still think that part of the reason the Prime Minister doesn't realize that what he did was wrong was that he didn't receive a decent legal briefing from his clerk of Privy Council. None was provided to him, or from his staff. But he did receive a decent legal briefing. It was from Jody Wilson-Raybould, the former Minister of Justice and Attorney General, who told him, watch what you're doing. You're interfering in prosecutorial independence. I mean, I know she didn't sit him down and get out a chalkboard and explain it. She didn't think she had to. What I find really troubling about what Mr. Dion uncovered is the idea that in any government governed by the rule of law, a Minister of Justice and Attorney General's position would be so deeply undermined by her colleagues. I know a lot of Liberals have said it was wrong of her to tape Michael Warnock. I understood under the circumstances why she felt it necessary. But the deeper distrust is to imagine that a report from a former Supreme Court judge, very respected jurist, John Major, peddled by SNC-Lavalin's lawyer, also former Supreme Court Judge Frank Iacobucci. I think it's the power of their titles and their previous their work on the Supreme Court blinded people around the cabinet table to the reality that the only legal advice they should be taking is from their own lawyer, the Attorney General. But what's really shocking to me is that they peddled this report undermining the judgment of their cabinet colleague, the Minister of Justice and Attorney General. They peddled it without even sharing it with her. And I ask my Liberal friends to imagine for 1 minute a scenario within which Jean Chrétien would have allowed his cabinet colleagues to circulate a memo that undermined Irwin Cotler. Can you imagine it? Or Pierre Trudeau would have allowed his cabinet colleagues to circulate a memo that undermined the judgment of John Turner. This is really scandalous. The Prime Minister is guilty here of the kind of offense for which resignation is appropriate. I leave it to him. I'm not calling for resignation. But it does strike me as beyond belief that this kind of thing could go on. It's not a small matter. It shouldn't be covered up. We really do need to ask Mr. Dion what he uncovered. We need to hear his opinion on the nature of further remedies, how much we should take steps to ensure that cabinet confidentiality is removed so that those 9 additional witnesses can be heard. I also want to say very clearly that I don't think this is a partisan issue. I think it's systemic. I think it's shocking that the senior civil service of this country could be manipulated by a transnational corporation in this fashion. And I think lots of other transnational corporations may have the same kind of access. And it's systemic regardless of who is in the PMO, regardless if it's a conservative or a liberal. We have to ensure that the machinery of government, that our civil service is not at the disposal of transnational corporations to do their bidding. I don't think it's about this prime minister and making it a political football in this election campaign. I think it's a much larger issue, and I think it's systemic. And I'd like to hear from the Commissioner of Ethics and Conflict of Interest. Je pense que nous avons une obligation maintenant morale.
I think we have a moral obligation to protect our democracy against the power of major transnational companies.
Thank you, Mr. Chair.
Thank you, Ms. May. Next up, Mr. Weir.
Thank you, Mr. Chair. I'd like to thank you and all members of this committee for giving independent MPs an opportunity to participate in today's meeting. One of the things I've really appreciated about being an independent MP is the opportunity to take a more dispassionate look at issues, and that's what I've tried to do in all the committee hearings on SNC-Lavalin. So I'd like to say a few words about my reading of the Ethics Commissioner's report and some of the topics that I think might be worth pursuing if this committee decides to hear from the Ethics Commissioner and perhaps other witnesses. The Commissioner's key conclusion is that there was a violation of Section 9 of the Conflict of Interest Act, which says that public office holders should not, and I quote, seek to influence a decision of another person so as to further the public office holder's private interests or those of the public office holder's relatives or friends, or to improperly further another person's private interests. Now, I don't think anyone is alleging that the Prime Minister sought to further the private interests of his family, his friends, or himself. I also don't think there's any doubt that many, if not most, public policy decisions will either further or detract from the private interests of various companies and individuals. So the key conclusion from the Ethics Commissioner is that the Prime Minister improperly tried to further another person's private interests. And of course, that finding hinges critically on an interpretation of what is improper. So I think it would be well worth this committee's time to dig into that with the Ethics Commissioner. We've heard a lot about findings of fact, but really this conclusion comes down to an interpretation of one word in the Conflict of Interest Act, which is something that I think could be open to challenge and certainly could be open to further exploration. So, Mr. Chair, it's a little bit unclear to me whether the Ethics Commissioner believes the Prime Minister is guilty of any kind of conflict of interest in the classic definition of that term. It does seem clear that the Ethics Commissioner believes that the Prime Minister is guilty of improperly furthering another person's private interests, but there's already been some debate about how that language should be interpreted, what's improper, and I would suggest that as an appropriate focus for this committee's work.
Thank you, Mr. Weir. Next up, we'll go to Ms. Ramsey.
And thank you to committee members for having me at the committee today. I'm having some serious deja vu. Having sat on the Justice Committee along with some of the other colleagues here on the other side, this experience that we're having right now feels very familiar to me, where we have silence from the Liberal members and we have opposition members who are laying out the reasons why we'd like to hear the truth. And I'm certainly appreciative of Mr. Dion's report, but it leaves many questions. There are still questions to be answered that are incredibly important, as my colleague mentioned, to the democracy of our country. My son is 18. He'll be voting the first time this year. And I can't imagine a country where the Prime Minister can break the law and not admit to it, not apologize to it, but that, quite frankly, somehow Canadians are going to accept. Is this the future now of Canada? That this is the bar that we're setting, that we're saying the highest office in the land, that individual can break the law. And there's nothing that can happen. He doesn't have any accountability to that. The players that are involved have no accountability to that. Mr. Morneau has been mentioned at this table. There are many questions surrounding his involvement, which he now, in some way, tries to say he can't recall, which seems incredibly unbelievable to Canadians. This matters. This is about the Prime Minister trying to corrupt the Attorney General's office. This report is incredibly important to Canadians, and I think it's a mistake if there are those sitting around this table who think that this does not matter to them, that Canadians don't understand enough about it, and you want to get stuck down talking about the McClellan report or different things, the DPA, that surround this. The Prime Minister of Canada has broken the law. We have questions for the Conflict of Interest and Ethics Commissioner that need to be answered and that Canadians deserve the truth about. This has been the pursuit of this entire thing that has been blocked by Liberals on a constant basis, to find the truth, to get answers to questions that people have. All of us walked in through the press today and were asked questions because this report leaves questions hanging. And we can't leave those questions hanging because this is an incredibly serious thing, regardless of who is sitting in the Prime Minister's role in Canada come this fall. We need to know whether or not, who is involved. We need to have other people come forward. And we can't accept that breaking the law in Canada is now okay for the Prime Minister. So I implore the Liberal members, as I've done many, many times on the Justice Committee, at this Ethics Committee, to allow the Conflict of Interest and Ethics Commissioner to speak before us. I understand, Mr. Chair, if he's waiting, then I would move to go to a vote so that we can allow that testimony to begin and have questions to him. So I move for a vote, please.
I have two others still to speak to this, so I'm not sure. Just give me a second. Yeah. We still have to go through. If the people on the speakers list want to give up that time to go to the vote, then that's a possibility. I don't see that right now willing to do that. So I have Mr. Gord next to speak, and then I have Ms. Reid again. So go ahead, Mr. Gord.
Merci, Monsieur.
Thank you, Mr. Chair. I'd like to say a few words. It won't be too long. This report, just the title makes my hair stand on end. Trudeau 2. It's the second report in the same session. The second time the Prime Minister has broken the law. And in the case before us, he broke Section 9. And I wanted to highlight that Section 9 says that no public office holder shall use official roles to try to influence the decision of another person in order to further their private interests or those of another person in an improper fashion. In paragraph 282, Commissioner Marion-Dion says that the authority of the Prime Minister and his office was used to undermine and attempt to discredit the decision of the Director of Public Prosecutions, as well as the authority of Ms. Wilson-Raybould as the main legal advisor to the Crown. It's a scandal. On the eve of the upcoming election, do Canadians deserve a Prime Minister who breaks the laws of his own country? It's staggering. I hope that the moral conscience of my colleagues opposite will allow us in the upcoming minutes, because the Commissioner is ready to come appear before us. We have more questions to ask. And there are things that are still hidden in this whole affair. We'd like to shed light on them. We'd like to know the whole truth. Canadians deserve to know the truth before the election on October 21st. I think in our democracy, having people at this high level with such an important title as Prime Minister, who doesn't seem to understand the separation of powers between the legislative and the executive and the judiciary, It's very concerning for all Canadians. Thank you, Mr. Chair.
See, Mr. Gord, next up.
Thank you, Mr. Good.
Thank you very much, Mr. Speaker. Mr. Chair. Mr. Chair, the reality is that what the Ethics Commissioner has found is that the Prime Minister improperly used political considerations in attempting to have the Attorney General to essentially overrule the Director of Public Prosecutions. The Prime Minister is saying that is not the case, that in fact it wasn't political considerations, that it had to do with something else, jobs. And my colleague, Mr. Poilievre, I think has completely debunked that notion, and I know that my colleague, Ms. May, would do the same thing in a heartbeat if she had the opportunity to do so. So we are at this impasse where we would like to know what the political considerations were that are noted in Mr. Dion's report and also alluded to in some recent interviews from Jody Wilson-Raybould and from Jane Philpott. Now, after the report was made public on August 15th, Jody Wilson-Raybould was interviewed by CBC, and it was a lengthy interview by Vashi Kapalis. And she was asked a number of times with respect to what had happened and her comments with respect to the report of the Ethics Commissioner. And in one of her questions, she made very clear that and if I will quote into the record, I would not change the actions that I took. I believe that Canadians want to see in their public officials, particularly ones that hold offices like the Attorney General of Canada, that they will be making decisions not based on political considerations, but based on the fundamental understanding of the law, based on the fundamental understanding about we maintain the fundamental tenets of our democracy and are constantly vigilant on that. And she says that she would not change any of her actions because she will not make decisions that are not embraced on principles or the values that she has always embraced. She goes on to say later on that upholding independence and upholding the rule of law was what she was doing in her role as the Attorney General. And a number of times she indicated in other parts of her interview that she had questions with respect to political considerations. After Ms. Wilson-Raybould's interview, Jane Philpott was further interviewed by Vashi Kapalis, and she got more to the point. She talked very specifically about considerations that should and should not be taken into account when decisions were being made. And this is what she says. She's asked the question whether or not there was a conflict for the purposes of benefiting a private corporation. The Ethics Commissioner determined, but the Prime Minister often speaks about his motivation. And if you say that you don't know for sure that it wasn't, why do you think he was motivated by, or what do you think he was motivated by? And Ms. Philpott says, I don't think it's motivations that concerns people as much as whether or not we hold in regard what is in the best interest of the country. And that we hold in regard the very pillars of what our democracy is founded upon. And one of those pillars is that our justice system needs to be independent. And, with my emphasis, Mr. Chair, and politicians who have the desire to further their political career, to ensure that they will win an election, to potentially support those who may have supported them financially or in other ways, those are not the kind of motivations that should be on politicians' minds when it comes to a criminal matter. And it's extremely clear that politicians and executive and legislative branch should not interfere with the judicial branch of government. Those were Jane Philpott's words, which caused me to think, well, what information does she have that causes her to have such a very strong point of view on what political considerations may or may not have been in consideration when decisions were being made? And that brings me, Mr. Chair, to the issue of this waiver. The reason why the Ethics Commissioner was unable to get further in terms of political considerations, other than the 4 times he clearly notes where he believes that the Prime Minister, through himself or through his staff, were politically interfering. The reason why he can't get any more granularity on it is because, as he noted, he was unable to get the relevant information that he wanted. And I'm going to read from his report on page 5, paragraph 14. Actually, I'm going to start with 13. In order to gain access to as much relevant information as possible, on March 29, 2019, I instructed legal counsel in our office to engage with counterparts in the Privy Council office to request that witnesses be enabled to provide all of their evidence to our office. Despite several weeks of discussions, the offices remained at an impasse over access to cabinet confidences. On May 3, 2019, I raised the matter directly with the Prime Minister during his interview. Through legal counsel, Mr. Trudeau stated he would consult with the Privy Council office to see whether the order in council could be amended. Now, the order in council that we're speaking of, Mr. Chair, of course, is the order in council that was passed by Cabinet in order to allow Jody Wilson-Raybould and Jane Philpott to speak up to a certain point in time. And after that point in time was reached, they could not speak to matters that had Cabinet confidence around them. On May 28, 2019, with the issue of access to Cabinet confidences resolved, I wrote to the newly appointed clerk of the Privy Council, Ian Shugart. I set out the concerns expressed by witnesses noted above, and I explained what I believe to be the legislative framework that at least implicitly authorizes our office to access such information. I cited provisions of both the Conflict of Interest Act and the Parliament of Canada Act that prohibit me from revealing confidences of the Queen's Privy Council in the context of public declarations of recusal and our annual reports, respectively. I explained that I understood these prohibitions to mean that our office would have prima facie access to this information, and I drew the analogy between these prohibitions and the restrictions on the disclosure of confidential information placed on me in the course of examinations, and why I would have similar access to and a similar prohibition on publishing Cabinet confidences in that context. That was the Ethics Commissioner's pitch on May 28 to the Clerk of the Privy Council, explaining why he should be able to receive the information that the Prime Minister said was being held back due to Cabinet confidence. In a letter dated June 13, the Clerk of the Privy Council declined my request for access to all Cabinet confidences in respect of this examination. Mr. Trudeau's legal counsel indicated that the decision on whether to expand the waiver was made by the Privy Council office without the involvement of the Prime Minister or his office. But as we know from this long and sordid, drawn-out affair that we've been witnessing since January, we all know that there's always somebody that can overrule a bureaucrat. And that's exactly what Mr. Trudeau wanted Jody Wilson-Raybould to do. So for him to say that he wasn't part of the decision actually is completely irrelevant, because he always has the power to tell the Clerk of the Privy Council what to do. However, I continue reading. Because of the decisions to deny our office further access to Cabinet confidences, witnesses were constrained in their ability to provide all evidence. I was therefore prevented from looking over the entire body of evidence to determine its relevance to my examination. Decisions that affect my jurisdiction under the Act by setting parameters on my ability to receive evidence should be made transparently and democratically by Parliament. Emphasis here, not by the very same public office holders who are subject to the regime I administer. I'm convinced that if our office is to remain truly independent and fulfill its purpose, I must have unfettered access to all information that could be relevant to the exercise of my mandate. I must be satisfied that decisions made by the most senior public office holders, including those discussed at Cabinet, are free from any conflicts of interest. In the present examination, I have gathered sufficient factual information to properly determine the matter on its merits. Because of my inability to access all Cabinet confidences related to the matter, I must, however, report that I was unable to fully discharge the investigatory duties conferred on me by the Act. Now, why is this important? This is important because the Ethics Commissioner is detailing very clearly that he sought to get information on Cabinet confidences that were outside the waiver the Prime Minister already had given. Jane Philpott, as well, in her interview, said very clearly when she was asked by Vashi Kapelis whether or not there was any further information that she thought was relevant that was covered by the waiver. She's asked, are you in possession of any information that you think the Ethics Commissioner should have had access to? Answer, there are pieces of information that I am aware of that I am not at liberty to speak about. She further goes on later to say, this is Jane Philpott again, so what I would point out to Canadians is what the Ethics Commissioner said is that he was unable to get enough information to make a determination in terms of whether or not there was a breach of the Conflict of Interest Act or not. So it didn't, in a sense, hold him back from being able to make a determination on this. But I would say, and this is from Jane Philpott again, that I can affirm that there are pieces of information that I am aware of, but that because of the oath that I made to Queen and Country to keep in secret that which shall be kept secret, according to the oath that I made as a cabinet minister, that unless I am released from that obligation, that I am not at liberty to share those pieces of information either with you or with the Conflict of Interest and Ethics Commissioner. So we know that there's more information out there. Jody Wilson-Raybould has said that, as has Jane Philpott, and indeed the Ethics Commissioner attempted to get it. He was unable to get it by virtue of the decision of the Prime Minister. That is not fully cooperating with the Ethics Commissioner, and again, as I said before, that deserves to be reviewed. More importantly, and most recently, there has been the publication of a book. And the book is written by a CBC reporter by the name of Aaron Wary. And in it, Aaron Wary had unprecedented access to the Prime Minister on this topic. Now, if you recall, Mr. Chair, I said to you that there are certain things that the former Attorney General couldn't discuss, that the former President of the Board of the Treasury Board could not discuss, that was not given to the Ethics Commissioner, that the witnesses were not allowed to talk to. And one of those things was what happened after the resignation of Jody Wilson-Raybould and what happened in the meetings between the Prime Minister and the former Attorney General, because that waiver was cut off when the former Attorney General left her time as Attorney General and moved to Veterans Affairs. And as you know, she resigned from Veterans Affairs after that. But miraculously, it would appear that the concept of cabinet confidence doesn't apply to the Prime Minister, much like every other rule seems to not apply to the Prime Minister, quite frankly, because in his complete access he gave to this writer, Aaron Wary, was to detail the meeting that he had with Jody Wilson-Raybould post her time becoming the Minister of Veterans Affairs. He's waiving cabinet confidence to a reporter in order to get his side out in a novel, and yet the Ethics Commissioner cannot receive this information. Jody Wilson-Raybould says there is information. Jane Philpott says there is information that is of interest to Canadians. So I would like to ask the Ethics Commissioner whether or not he has taken any legal advice as to whether or not there has been a waiver of this cabinet confidence by the Prime Minister himself to cover the period of time that is currently not and extend it over the period of time that would be of great interest to Canadians. And that would be something that I think that would be of great interest to Canadians, and I also believe that it is something that goes to the heart of ensuring that we get to the bottom of the matter. And picking up on what Elizabeth May said just a few minutes ago, this is the kind of scandal and the kind of actions that warrant the highest level of punishment. We can't force that, but it can be at the discretion. And clearly, as she said, it's not going to be happening, but we still owe it to Canadians to understand and give them the truthful information, what has happened, and not just take the word of the Prime Minister, because we have seen over and over again, the Prime Minister simply does not keep his word. Thank you.
Thank you, Mr. Raitt. Next up, Mr. McKinnon.
Merci, Monsieur le Président.
Thank you, Mr. Chair. We all appreciate the work by the Ethics Commissioner and the work of his office in supporting all members of Parliament and this Parliament. And in this case, in the case of the present report, the Prime Minister thanked the Commissioner and accepted his report. This issue was studied thoroughly. The Justice Committee, as we've heard, held over 13 hours of testimony from 10 different witnesses over 5 weeks. In addition, we now have a 63-page detailed report from the Commissioner following months of work on his part. The Prime Minister was clear. He was focusing on protecting jobs for thousands of Canadian workers. That was his only focus. I think that's what any Canadian who has a job, whose job is at risk, would expect. Now, we also have a guide from Anne McClellan, who spoke to former attorneys general.
You have a point of order? Go ahead, Mr. Angus.
Yes, the Justice Committee shut down their study. If they want to have Anne McClellan, they can go back to the Justice Committee. This is about the Ethics Committee. So to be bringing Anne McClellan, a former Liberal, report in, go back to the Justice Committee, which you shut down. This is about the Ethics Committee and Mr. Dion's report.
Thank you, Mr. Angus. It's not really a point of order, but Mr. McKinnon, proceed.
Je reprends ma phrase, Monsieur le Président.
I'll pick up where I left off, Mr. Chair. We have a guide from Anne McClellan, who spoke to all former attorneys general. That helps to clarify the relationship between the Attorney General and their colleagues at Cabinet. The Prime Minister has already committed, before all Canadians, to put in place her recommendations. The combined processes of the Justice Committee and the Commissioner, over the course of months, many hours and pages, did detailed, thorough work, and it is clear now, following the comments of my honourable colleagues, that the real goal of the opposition is simply to engage in politics.
The Commissioner and his office do to support all members of the House and at all times. The Commissioner's report is quite detailed, and Canadians have had a good opportunity to familiarize themselves with the content. The Prime Minister has thanked the Commissioner and accepted the report. Though he disagrees with the conclusions, especially when so many jobs were at stake, and that is no laughing matter, he has already announced that steps would be taken to ensure no government goes through a similar situation in the future. This government, as should any government, takes seriously the responsibility of standing up for jobs and growing the economy. And it's the responsibility of any Prime Minister to stand up for people's jobs. In fact, it's the responsibility of all members of Parliament. And people whose jobs are on the line should expect no less of their elected representatives.
Point of order, Mr. Chair.
Yeah.
Mr. Poilievre.
It is customary that when a member quotes a document in a committee that he or she table the document so that all members can see it. The member across the way claims to have an analysis from the government showing 9,000 jobs are at stake. Can he just table that so we can all have a look at that analysis? Thanks.
I would ask Mr. McKinnon, are you able to table that for the committee today?
No, that's not. Nor is that a point. Nor is that a point of order, Mr. Chairman.
Okay.
Nor is that a point of order, Mr. Chairman.
Continue
but
on,
with
Mr. McKinnon.
That member and his rich experience in Canada's private sector will have to look at his views with some skepticism too. It's the responsibility of any Prime Minister to stand up for people's jobs and livelihoods across the country, and it should be the job of all members of Parliament, while upholding, of course, at all times, the rule of law.
McKinnon, a point of order, Mr. Angus.
Yeah, this is all fine, but we are talking about a specific report. And the only job that is referenced at being risk is in the report where the Prime Minister said he was speaking as the MP of Papineau. So I would ask my colleague, since Mr. Murnau had no evidence of job loss, why he's making facts up now when we're talking about a factual finding of guilt against a Prime Minister who improperly used his position to further the interests of a very powerful corporation. That is the issue before us, not this spin of falsehood of jobs, because that was proven false by the Ethics Commissioner. So if the member has evidence that wasn't supplied to the Ethics Commissioner, Perhaps it's one of the 9 witnesses who were not allowed to testify that knew all about these jobs. I'd ask him to put that on the table or spare us these Liberal talking points that have been proven false and have continued the falsehoods by this Prime Minister.
Thank you, Mr. Angus. That's debate. We'll go back to Mr. McKinnon to finish your statement.
Mr. Chair, where I come from, we listen to folks and then we get to speak and we have a healthy exchange. I've been now interrupted 3 times by things that were not points of order, and I hope that the committee will indulge the rest of our statement.
Mr.
Out of collegiality
McKinnon, actually,
and politeness.
to be clear, the chair has the discretion to hear points of order and to hear
Of course
debate,
he does. Yeah.
and has a responsibility to keep things in order.
I'm just expressing through you,
I
Mr. Chair,
expect as one of the
a hope for
visitors to our committee
politeness.
to just acknowledge the chair and his role in keeping things in order. Thank you.
Thank you,
Mr.
and I
McKinnon.
appreciate your chairmanship today, Mr. Chair. The Prime Minister's objective throughout, as he stated, was to protect thousands of jobs in Canada, all the while ensuring the integrity and the independence of the justice system. As has been confirmed on multiple occasions, no direction was ever given to the Attorney General. Former Attorney General Anne McClellan also authored a report, having spoken with all former Attorneys General, as well as constitutional scholars, and offers recommendations, including a process and a set of principles by which to guide the relationship between the Attorney General and the government. Both the Prime Minister and the Attorney General have already stated that they will be looking at how to best implement those recommendations, such as the protocol on interactions with the Attorney General and better education for all parliamentarians on defining the role. Now, the matter before us today has been studied quite extensively. The Justice Committee held over 13 hours of comprehensive testimony from 10 different witnesses over a 5-week span. And we now have a very thorough 63-page report by the Commissioner. The opposition's claim to simply wanting the facts is contradicted by the fact that what they seek is found in the Commissioner's report. It is already public, on top of the 13 hours of testimony that I just referenced. So the only conclusion that I and members of this committee can come to is that the opposition seeks to prolong this process for reasons of politics, reasons of partisan games, and it is for that reason, Mr. Chair, that we will be opposing this motion.
We'll go on next to Mr. Erskine-Smith. Go ahead.
When I was first made vice chair of this committee, I don't think anyone realized how popular we'd be, so welcome everyone. 2 points of clarification first. So when Ms. Ray talks about procedural fairness, of course, a decision maker owes procedural fairness to the subject of an investigation. It's not the other way around. And to silencing Ms. Wilson-Raybould, I watched hours of testimony before the Justice Committee. I read 43 some odd pages of testimony in which at the very end she said she had nothing more to add a formal process. So I think just 2 points of clarification. I'm not going to support this motion because of any, Sheer was in the riding yesterday, and so I just want to be clear, I'm also not supporting this motion because of any purported grassroots conservative campaign. I got 10 emails from my riding. That's not what motivated me. I will be supporting this motion, though, to invite the Commissioner to discuss his report, 1, in the interest of transparency and accountability, and 2, because in my own considered view, I think the Ethics Commissioner's conclusions are actually legally flawed in many respects, and I'd like to ask him some questions about his legal mistakes. So I've given a lot of thought to what happened. I've read what feels like a never-ending set of materials and coverage. And in the interest of making probably nobody happy, I want to share a few of my own conclusions, a number of which I've shared publicly before. So first and generally, I think it is both true at the same time that the then Attorney General did not exercise sufficient due diligence on the file, but it's also true at the same time that the PMO exerted pressure that should not have been exerted. The Shawcross Doctrine states that an Attorney General may but is not obliged to consult with colleagues in the government, and indeed it would be in some cases a mistake not to consult. A 2014 General Directive states it is quite appropriate for the Attorney General to consult with Cabinet colleagues before exercising his or her powers under the DPP Act in respect of criminal proceedings. Indeed, sometimes it will be important to do so to be cognizant of pan-government perspectives. Now, McClellan's report's also clear in examining the evidence that the Attorney General could have engaged in conversations with the DPP, which she suggested she could not have, could have asked for more information and solicited a second opinion. Now, to understand all public policy considerations here, and I take Ms. May's point that there was not a sufficient economic impact analysis. I'll tell you, if Ms. May or I were, or perhaps Mr. Kent were the Attorney General, the right course of action would have been to request an economic impact analysis from the Finance Minister or a third party when you've got a Section 13 notice, public interest notice from your DPP. And while Commissioner Dion was right that these considerations should not bear on his strict analysis under the Act, they do color the overall situation, and the Deputy Minister's comments in testimony to Dion raise the same concerns for me. At the same time, Dion's report and its factual findings make clear that the PMO exerted pressure that should not have been exerted. The Shawcross Doctrine is clear that the government is not to pressure the Attorney General at all for any reason. And McClellan's recommendations to establish new protocols for existing standards are themselves an acknowledgement that what took place should not have taken place. It is important that the Prime Minister has acknowledged mistakes were made, and I trust that McClellan's recommendations will be implemented. Third, and I know my Conservative colleagues, perhaps all colleagues on the other side will disagree with me, but I personally, having thought about this a lot, I think that the reaction and outrage to this situation has been disproportionate to these original mistakes of improper pressure, and I'll give 3 reasons. One, in my view, a DPA should have been more seriously considered. Organizations are made up of good people and bad people. When bad people do bad things in those organizations, they should be held criminally responsible to the fullest extent of the law. But the good people in those organizations, so long as the organization has reformed their practices, those good people, the employees, the innocent employees, should not suffer as a result. 2, given that this was a new law and that the Attorney General has never intervened under the DPP Act, a second opinion from Chief Justice McLaughlin, former Chief Justice McLaughlin, makes sense to me. I disagree with Dion's finding that there's any tantamount direction, but from what I read from his report, I can see, in fact, how there were repeated efforts to ask for a second opinion and improper repeated efforts to ask for a second opinion. Where I disagreed in reading his report, I could see no evidence that the analysis or advice of Chief Justice McLaughlin was in any way predetermined. And he made that factual finding, which I think is an incorrect factual finding. A second opinion from a respected jurist in this situation, I think, would have been reasonable. And lastly, in the end, there would have always been a great deal of transparency, even if the Attorney General had succumbed to that improper pressure and changed her mind. McClellan notes that with the creation of the DPP in 2006, one of the very few things I will say the former Conservative government did well, but the creation of that DPP in 2006, the federal justice system has now undergone the most significant organizational change in the last half century, according to McClellan, and any decision by the Attorney General to intervene must be in writing and public. And again, McClellan notes that its use would bring a high degree of public and political scrutiny. Lastly, and related, I do not accept Dion's findings that there was a conflict of interest. In my view, that conclusion is legally incorrect, and Mr. Weir, you've highlighted some of the reasons why. The Prime Minister and his staff were, and you can read Dion's report on multiple occasions, they are referencing jobs, and we can question the evidentiary foundations of their intentions, but their intentions, the conversations with Jerry Butts, the conversations with the staffers, Mr. Trudeau himself are saying we care about protecting jobs, and Dion documents multiple instances of this. So they were standing up for jobs, albeit mistakes in doing so, but in my opinion, having read the evidence, they were standing up in the public interest. At no time were they improperly furthering a private interest under the Act. There was a breach of Shawcross, but not a conflict of interest. A conflict would occur if, as a public office holder, I furthered a family member's interest, I furthered a friend's interest, my own interest, or as any basic statutory interpretation where we read the Act consistently with reference to other parts of the Act and the purpose of the Act, we would find that basket clause that one ought not to improperly further a similar interest. Conflicts are inherent. They demand recusal. They are unchanged, actually, by proper or improper pressure. Making mistakes to stand up for the public interest is not a conflict, though it was a breach of the Shawcross Doctrine. The Commissioner's analysis and conclusions are, in my own view, legally wrong on this point. Now, to the extent that partisan considerations, because those are mentioned on 4 occasions in the report, were brought to bear, First, no one should have brought these concerns, and in fact, McClellan's protocol would prevent any politically exempt staff from participating in any conversations going forward. Now, of course, Mr. Trudeau said I'm the member from Papineau. His own evidence to the Commissioner was anchored in his experience with his constituents and his understanding of the negative consequences of layoffs for communities. And I'll tell you, if Andrew Scheer is elected and stands up for dairy farmers, or I continue to stand up for animals, or if the member from Oshawa had said, you know what, I'm the member for Oshawa and I'm concerned about the GM plant closing, or I say to Bill Blair, I'm the member from Beaches East York and you're damn right, we have to do something about gun violence, it's not so clear that these are always partisan considerations. As McClellan cites one respected scholar, in many instances, and I think we can all, as partisan politicians, acknowledge this, in many instances, the approach that is taken may benefit the public while also serving partisan interests. And lastly, public opinion will be the final arbiter of whether the primary motivation is nonpartisan, and yes, motivations do matter. In my view, the primary motivation in this instance was to protect the public interest in jobs. The public interest was pursued improperly, but at no time did the Prime Minister improperly further a private interest. The Commissioner is legally wrong, and I would like him to sit right there so he could answer questions about how he got this analysis so completely wrong.
Thank you, Mr. Erskine-Smith. Go ahead quickly, Mr. Angus.
I have great respect for my honourable colleague. I worked with him for 4 years. He's very complex. I just need to hear, did he say he was voting against or voting for to have Mr. Dion speak to our committee? That's I just need to clarify that.
I'm voting for bringing Dion to this committee.
Thank you, my friend.
Thank you for the clarification.
Ready to...
We do have a speakers list again, so we have